People of the Philippines versus ALLAN, ALMAYDA and HOMERO QUIOGUE. GR 227706 June 14, 2023. Facts. By information dated April 20, 2012, accused appellants were charged with violation of Section 5, Article 2 of Republic Act 9165 thus. That in and about the 19th of April 2012, in the city of Legazpi, Philippines and within the jurisdiction of this honorable court, the above-named accused, conspiring, confederating, and helping each other for a common purpose, did then and there willfully, unlawfully, and feloniously sell and deliver to a poser buyer 2 heat-sealed transparent plastic sachets containing methamphetamine hydrochloride, popularly known as shabu, a dangerous drug, weighing 0.318 gram and 0.072 gram respectively, in consideration of 4,500 pesos, without authority of law. In March 2012, a confidential informant reported to the Philippine Drug Enforcement Agency, Regional Office 5, the illegal drug activities of QUIOGUE and an alias, Kala, who later turned out to be ALMAYDA. A buy-bust operation was, thus, organized consisting of Philippine Drug Enforcement Agency Agent Marinina Z. Bello as team leader, Agent Daniel Tan as poser buyer, Agent Enrique Lucero as arresting officer, and other Philippine Drug Enforcement Agency agents as members. The confidential informant arranged a meeting with accused appellants to purchase 2,000 pesos worth of shabu on April 18, 2012. On even date, only ALMAYDA showed up at the meeting place to tell the confidential informant and Agent Tan that he could only sell a minimum of 4,500 pesos. ALMAYDA, in turn, passed the money to QUIOGUE. Agent Tan took off his bull cap to signify to the team that the sale had been consummated and to arrest accused appellants. When the rest of the team arrived, Agent Lucero searched accused appellants and recovered from QUIOGUE the buy-bust money. While still at the scene of the crime, Agent Tan marked the 2 plastic sachets with DMT A4-19-12 and DMT B April 19, 12, respectively. Photographs of the accused appellants and the seized items were also taken at the scene. Thereafter, they all proceeded to the Philippine Drug Enforcement Agency Regional Office, where Agent Tan conducted the inventory of the seized items in the presence of accused appellants, Barangay Chairperson Maria Jane Azatillo, Barangay Kagawad Rolando Belbs, Media Representative Romeo, and Department of Justice Representative Jesus Arsenio Aragon. After the inventory, Agent Tan brought the seized items to the Philippine National Police Crime Laboratory for forensic examination. PNP Medical Officer Flora Bumale received the items and turned over the same to forensic chemist Wilfredo Idian Pabustan, Jr. Per Chemistry Report Number D, 53-2012 dated April 19, 2012, forensic chemist Pabustan, Jr. found the specimens positive for methamphetamine hydrochloride. Issue: whether or not the accused appellants are guilty beyond reasonable doubt for violating Section 5, Article 2 of Republic Act 9165. Held. We reckon with the chain of custody in drugs cases, specifically the first link, which refers to the seizure and marking which must be done immediately at the place of the arrest. 2. It includes the physical inventory and photograph taking of the seized drug, which should be done in the presence of the accused or her representative or counsel, together with an elected public official, a representative of the Department of Justice, and the media. Here, it is undisputed that the physical inventory and photograph taking of the seized items were conducted at the Philippine Drug Enforcement Agency office and not at the place of arrest. Poser buyer Agent Tan testified that he marked the plastic sachets with DMT A April 19, 12 and DMT B April 19, 12 at the place of arrest. But the team then returned to the Philippine Drug Enforcement Agency office to conduct the inventory and photograph taking in the presence of Barangay Chairwoman Azatillo, Barangay Kagawad Belbs, Media Representative Romero, and Department of Justice Representative Aragon, and accused appellants. Importantly, Agent Tan failed to give any justification why the inventory was not conducted at the place of arrest. In the recent case of People versus Casa, the court settled that, in case of warrantless seizures, the inventory and taking of photographs generally must be conducted at the place of seizure. The exception to this rule, where the physical inventory and taking of photographs of the seized item may be conducted at the nearest police station or at the nearest office of the apprehending officer or team, is when the police officers provide justification that 1. It is not practicable to conduct the same at the place of seizure, or 2. the items seized are threatened by immediate or extreme danger at the place of seizure. As held in Casa, when the police officers are able to provide a sensible reason, which is practicable, consistent, and not merely generic or an afterthought, then the courts will recognize that the police officers indeed may conduct the inventory at the nearest police station or the nearest office of the apprehending officer/team. Such reason must be indicated in the affidavits of the police officers who participated in the buy-bust operation. As stated, the prosecution witnesses here failed to give any justification, much less a sufficient one, why the inventory had to be conducted at the Philippine Drug Enforcement Agency regional office instead of the place of arrest. Evidently, therefore, the first and most important link was already broken early on. As for the succeeding links, compliance with the requirements does not serve to cure the incipient breach which attended early on the first link in the chain of custody. As held in People v. Ismail, there was already a significant break such that there can be no assurance against switching, planting, or contamination even though the subsequent links were not similarly infirm. In other words, there is no way by which the already compromised identity and integrity of the seized drug items can ever be cleansed of its incipient defect. Hence, accused appellants must be acquitted as a matter of right. In view of the procedural infirmities in the chain of custody, the integrity and evidentiary value of the seized items cannot be said to have been preserved. These procedural infirmities cast serious doubt on the identity and integrity of the corpus delicti. The metaphorical chain did not link at all, albeit it unjustly restrained appellants' right to liberty. If the chain of custody procedure had not been complied with, or no justifiable reason exists for its noncompliance, as in this case, then it is the court's duty to overturn the verdict of conviction. As the court stated in People v. Macad, we recognize the pernicious effects of dangerous drugs in our society, but the efforts to defeat or eradicate these cannot trample on the constitutional rights of individuals, particularly those at the margins of our society who are prone to abuse at the hands of the armed and uniformed men of the state. Time and again, we have exhorted courts to be extra vigilant in trying drug cases, lest an innocent person is made to suffer the unusually severe penalties for drug offenses. Accordingly, the motion for reconsideration dated April 7, 2022 is granted. The resolution dated November 11, 2021 of the court is reversed. Accused appellants ALLAN ALMAYDA y Selfides and HOMERO QUIOGUE y Adornado are acquitted and ordered immediately released from detention, unless they are being lawfully held for another cause.